All right, I've got a few things to go over today, and one of them you'll want to stick around definitely for today's filing by defendant James Finch. Now the federal judge has everything to acquit or not to acquit. That is the question, as Hamlet might say. Right? Always got to bring in Shakespeare. Bernie, stop being so highbrow. So today, and the filing was super interesting. Only 11 pages, really 10 that I'll read. Ooh, if you want to understand why the prosecution has no case against James Finch, it's not like the evidence is weak, right? It's not like it's tenuous. It's more like the evidence is more like I'm thinking of a word. I'm reaching for a word. Absent. That's what it's more. It's absent or fake, made up. I'll prove it. I'll prove it. We'll go over that. Big deal. Big deal. You know what is also a big deal is in that same gigantic U.S. federal courthouse in Tallahassee, in the Beacon of Bay County, where we broadcast from. There was a major jury decision today. Raise your hand if you remember who Andrew Gillum is. Andrew Gillum ran as the Democrat candidate for governor against Ron DeSantis in 2018 and only lost by 0.5%. We almost had Governor Andrew Gillum. We would have seen soon afterward Andrew Gillum, the governor, naked on the bathroom floor, overdosed with some male prostitutes. The governor's not available for appointments today. Oh, geez. Is it anything serious? No. It's, we got it handled. I mean, it was close. Well, gosh, as far back as 2010, Erwin Jackson in Tallahassee would go to the city council meetings, the Tallahassee city council meetings. And Andrew Gillum was on the city council, and then he was the mayor. Do you remember in 2016, he took that lavish trip to New York and got the expensive Hamilton tickets and a bunch of fancy dinners and booze and a big boat trip. Remember all that? Well, Erwin Jackson filed an ethics complaint. Are you ready for this? And it went all the way to the end where Andrew Gillum made a plea deal. He confessed that he did indeed receive gifts in New York that he didn't put on the forms, and it exceeded the 100, all that stuff. So he's admitted to doing that in the ethics complaint. And then the FBI said, Mayor, can we talk to you? And they did a formal interview with him, like they did with Antonius Barnes and Michael White and these guys. They did a formal interview with him. He was under investigation. And they said, hey, when you were in 2016, when you were in New York, who gave you those Hamilton tickets? And he said, my brother. Wait, who did? Are you sure? Yeah, my brother did. What about all the other stuff, the dinners and the boat trip and the liquor? What about the other gifts? There were no other gifts. Nobody gave you any gifts? Nope. Well, he went on that trip with a couple of businessmen who gave him the gifts. The businessmen themselves were undercover FBI agents. So when he was asked later, and it was recorded, obviously, Mayor Gillum, where did you get all that stuff? He lied to them, and it was recorded. And the jury for 5 days has been deliberating over this count 1, lying to the FBI with actual proof, and also 18 other counts of wire fraud, which were payments. He and a lady, there was a nonprofit, and they split the money of the nonprofit. And so those are charged as wire fraud. here's what happened. Let me show you. All right. Look at this. Not guilty of lying to the FBI. Wow. 12 jurors, all 12, unanimous, listened to the tape, knew that the FBI was undercover and gave him the gifts, and knew that he told the FBI that didn't happen. And 12 jurors voted not guilty of lying to the FBI. Now, a couple of days ago, I think it was on Friday, the jury, might have been Monday, the jury came back and had a question for the judge, Judge Windsor, Judge Windsor, federal judge. And they said he's being accused of telling 3 lies to the FBI. All right. This is what the jury all came out and asked the judge. They had a question. Or it might have just been a note. And they asked the judge, how many lies does it take to go to prison? And the judge said, just 1. The jury said, oh, man, Andrew's in trouble. But they said not guilty to any of those 3 statements that he made to the FBI. And then on counts 2 through 19, 2 through 19, there was a hung jury on the conspiracy and the wire fraud between him and the lady, the older lady that they had the nonprofit together. So I told you that jurors usually only give a hung jury maybe 5% of the time. Well, on counts 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, on 18 counts, the jury was deadlocked. Hung jury on those. So Gillum avoided a conviction today, and so did the lady. All right. So now, let me get rid of this. So now Andrew Gillum and the lady, Letman Hicks, her name is Letman Hicks, Sharon Letman Hicks, now they are in the same situation that James Finch is in. There was a mistrial, and so the prosecutors, they can retry counts 2 through 19, and they say they intend to. It was the same prosecutor. It was Andrew Grogan, the assistant U.S. attorney. So it was Andrew Grogan versus Andrew Gillum. And Grogan lost. Now, you hear all the time that the feds have a 98% conviction rate. Well, they count all of the plea deals. It's not nearly that high when they actually go to trial and a jury decides. And but it's really bad for a federal prosecutor to lose and to get hung juries in federal trials. And this is really Andrew Grogan's breakout moment, because the lead U.S. attorney, Stephen Coons, who brought 64 charges against Mayor Margo Anderson in 2020, and 84 charges total against Mayor Anderson, James Finch, and former Commissioner Antonius Barnes. 86 charges. Well, all of them were dropped against Margo Anderson. And all of them were dropped except for one, and that's going to come into play when I read you this in a moment, against Antonius Barnes. Barnes is not being charged of accepting a bribe. Barnes is only being charged with not listing, and this is what the government calls it, the prosecutors. The prosecutors say, and they're charging Barnes with not listing business loans from James Finch, the liability he has, right? The debt he has to Finch. They didn't list that in a bank application, but they call it business loans, the government. They don't call it bribes. So anyway, so now the U.S. attorney, the guy who calls the shots on who's going to be prosecuted by the United States of America in the Northern District of Florida. His name is Jason Cootie. Now U.S. attorney. He replaced Larry Keefe after Biden got 78 million votes or 87 million votes. However many it was when they stopped counting. At that point, Keefe had to resign, and then the U.S. attorney was replaced. So it's now Jason Cootie. And so Jason Cootie has to decide, does he want to bring back those charges against Andrew Gillum? And does he want to bring back the charges against James Finch? And put his assistant U.S. attorney, the lead prosecutor now, Andrew Grogan, who now has a few blemishes in his big rise in the Justice Department. This is what happens when you try to prosecute cases in front of juries that are weak. Now, I'll say this. Somebody challenged me on this too, by the way. Somebody on Facebook said, "Oh, you really believe the FBI, don't you, Bernie, when they go after a Democrat?" That's what somebody said to me. So I find that to be hypocritical. And I said, "Oh, yeah. Well, the difference is there was an actual tape recording, and the undercover FBI agents are the ones who gave him the gifts. It's a pretty big damn difference. You got to admit." So anyway, so that's what's going on there with Andrew Gillum. He's in a holding pattern, but he escapes, or he evades a conviction. And so does Sharon Letman. What did I say her name was? Gosh, I forgot. The lady that was also on standing trial. Are you ready for this? I want to show you the entire filing from today, and this is it. Federal Judge Mark Walker now has everything he needs to decide whether to acquit James Finch based on no evidence, which he's required to do, the court's required to do, or whether or not they're going to go and have another trial against James Finch on those 2 counts down the road. But first, you know what I'm going to do? I want to remind Panama City voters that in less than 2 weeks, on the 16th, on that Super Tuesday, you have a chance to vote for a mayor. There's a runoff. It's close. It's so close that St. Joe is worried. And St. Joe's worried because Panama City residents could actually get a mayor that represents them and not the big developers. Doc Rowan is running for mayor of Panama City. The city wants to spend $170 million to build a new civic center. They could have restored it for $12 million. Why are they so determined to spend more than $150 million than they should? And they want to shut down the boat ramp in the marina. If they have their way, generations of boaters and fishermen would become second-class citizens. It's time for a mayor who puts you first, rather than the big developers. Vote for Doc Rowan on or before April 18th. All right, and I'm going to ask your indulgence right now because I want this next segment to be smooth. I don't want to interrupt this 10 pages that I'm going to share with you because it is hot. Just filed today. So in order to do that, I want to thank 2 sponsors that allow me to do this by sponsoring the show. So let's do these 2 first, and then I'm going to get into it.
When your life is on the line, hire the lawyer who lives in our community, works in our community, and worships in our community. I'm Al Saulene, your Panama City Beach lawyer. 850-215-0628.
Don't let back pain and neck pain get you down. Find relief at Brown Chiropractic Center on St. Andrews Boulevard in Panama City. Dr. Sherry Brown helps people heal naturally with chiropractic adjustments and deep tissue massage. Call 769-3777. All right, let's get to it. Look at this. This is, if you want to read this yourself, it is on watchdogsociety.org. All right, watchdogsociety.org, and you'll have everything you're seeing with me right here. All right. All right, let's click on the PDF. Booyah. Look at that. Let's make it big. There we go. Gosh, could you imagine seeing your name there? I mean, could you imagine seeing United States of America versus John, Mary, whatever your name is? That is amazing. So here we go. The reply. This is really okay. So Finch submitted a motion probably about 5 weeks ago, 6 weeks ago, and it was a renewed motion to acquit, for the court to acquit him after the jury said we can't do it. They were deadlocked. All right. Judge Walker said, as close as it is, I'm going to let the jury decide. It's called a federal Rule 29. It's almost never granted, but a defendant has a chance to do it twice. Once right after the prosecutors finished their closing statements, which they did. Judge Walker told the prosecutors that you barely survived this Rule 29 based on lack of evidence. Then after the jury said, we can't convict him on this, it was a deadlock on both counts, the conspiracy to bribe and the bribe itself, which is a $5,000 check. All right, so he filed the motion. The government said after 2 weeks, the government told the judge, we need another 2 weeks to reply. And they did. And so this is the last piece of this. This is Finch's rebuttal to the government's opposition of the judge acquitting him. All right. In response to defendant Finch's renewed motion for judgment of acquittal, the government's, and this is, remember, Finch's attorneys talking here. The government stretches the law, facts, and evidence to illogical and unreasonable ends. The government's response is saturated with bare conclusory statements that require impermissible inference stacking. Accepting the government's logic and arguments would in effect render all Rule 29 motions superfluous. Indeed, no court would ever be permitted to grant a motion for judgment of acquittal if a juror was allowed to be as unreasonable as the government suggests. There are 3 reasons they give for the court to acquit James Finch, which Judge Walker can now do at any time. 1, the government failed to present sufficient evidence of an agreement and corrupt intent. This is huge. And this is self-evident. The government claims that it presented direct evidence of both Mr. Barnes's and Mr. Finch's corrupt intent. Yet the government does not cite to documents, exhibits, or portions of testimony of the direct evidence. The government then leaps to a conclusion that the so-called non-specific, unidentified direct evidence is also evidence of a conspiratorial agreement. Surely this cannot satisfy the legal requirements under Rule 29. To make an appropriate determination as to the sufficiency of evidence, it is necessary for the court to analyze the specific evidence presented at trial and draw reasonable inferences from that evidence. Without specific citations to the record, it is virtually impossible to evaluate the government's claims of sufficiency of evidence. Nonetheless, we will attempt to address the government's arguments. First, the government claims it presented the following direct and circumstantial evidence. 1, quote, beginning in September 2015 and continuing until December 2017, the commissioner solicited and received $45,000 in checks purportedly as business loans from the defendant. Second, the allegedly loaned monies were never repaid. Based on this summary, the government then argues that a rational juror could conclude that the $45,000 in checks to Barnes from Mr. Finch are not actually business loans. So the question comes up, why do I keep saying $5,000 when it's $45,000? Because the charge 1 is conspiracy for James Finch to bribe Barnes. Count 2 is 1 check only, a $5,000 check. Now, over the course of time, Finch loaned Barnes $45,000 all of which was deposited in his business account. Okay. The government says they're not actually business loans. Not only is this an unreasonable and unsupported interpretation of the evidence and testimony, but the government has already conceded the legitimacy of the loans. This is important now to this court and to the jury. So from Barnes's statement of fact, where he pled guilty, they said, we won't charge you for taking bribes if you admit that you did not list the business loans on your bank application for a loan. So that's what this is quoting from. They're quoting from the government's, the prosecutor's own document that is a statement of facts for Antonius Barnes. This is a quote from that document, the statement of facts. Had the credit union known that Barnes had outstanding loans of $45,000 to Finch, the credit union would not have extended a loan to Barnes. So the prosecutors themselves, in their statement of facts for Barnes, in his plea deal, says that it's a loan. If it were a bribe, Barnes they wouldn't say Barnes is going to be paying him back. All right. So the prosecutors themselves call it a loan. It's kind of a big deal, wouldn't you say? The government should be estopped from taking inconsistent positions. You say, Bernie, they made a mistake. I thought so too. But estopped is actually a legal term. Basically means the court needs to stop them from making these inconsistent arguments. Bernie, the attorney, learned something today. All right. To protect the integrity of the judicial process, this court should not permit the government to take diametrically inconsistent positions according to the exigencies of the moment. In other words, what suits them at the time. Isn't this something? Second, this is not like WMBB described it, is it? This is not like the big press conference described it at all. Imagine how surprised I was when I found all this stuff. You know, as I started to learn about this, I said, oh my God, I got to tell everybody. It's important to know. Second, the government claims it presented direct or circumstantial evidence that defendant Finch was actively, okay, this is what else they say. Prosecutors are saying that Finch was actively pressing city officials to expand his contracts and to implement them in a way that maximized the work and payments to Finch's company. Notably, the government does not include any citation to an exhibit or testimony to support this reckless claim. The government does not include a citation because there was no testimony or evidence to support it. In fact, the pretrial testimony supports the opposite conclusion. The government's witnesses testified favorably to Mr. Finch, indicating that they had no problems with Mr. Finch and that he had never offered them anything of value in exchange for official action. Every single government witness said that. Every one of them. All the witnesses against Finch said that. And the prosecutors have absolutely no evidence to the contrary, but there is evidence that I've shown you, the actual meetings that are the opposite of what the prosecutors are saying. This is really, really bad. Really bad. The same was consistent with all former public officials that testified during defendant's case in chief. In other words, the prosecutors, what they told the jury in the trial. All right. Detailing the unrebutted favorable testimony from former Commissioner Judy Tinder and former Bay County Sheriff and FDLE Director Guy Tennell. As expected, the government almost exclusively relies on Mr. Barnes' statement of facts that in and of itself is not evidence, direct or circumstantial, of Mr. Finch's intent, which has to be proved. In its response, the government does not contest or rebut. Prosecutors do not disagree with any of these 4 points. 1, Barnes's statement of facts does not contain Barnes's actual statements. 2, the document was a government drafted summary of items it believed could prove should Barnes have gone to trial. 3, the statement in paragraph 13 relates to Barnes's intent, not Finch. 4, Finch was not a participant in the Barnes's change of plea hearing. In other words, Barnes's statement of fact says nothing about Finch's intent. They inserted a paragraph to say Barnes had the intent. And Barnes has always denied that. They inserted that after the fact. Thus, Mr. Barnes's statement of facts is not evidence of Finch's state of mind, which is a necessary element for count 1 conspiracy, nor is it evidence of Finch's intent or understanding, which are necessary elements for count 2. The check, the $5,000 check. The only evidence of state of mind comes from Barnes's trial testimony. Here, he denied any allegation of bribery agreement between himself and Mr. Finch. Barnes did not sell his vote. Finch did not buy Barnes's vote. There was no corrupt state of mind. Finch never said anything or did anything at any point to make Barnes think defendant Finch intended to bribe him. These are things that were said in the actual trial to the jury under oath. When weighing the possible theories supported by the evidence, the court, and this is case law, this is the standard that Judge Walker is bound to consider and to apply when he rules on whether or not to acquit Finch. And it could happen tomorrow. It could happen next week, which is what I would guess. But it can happen at any time now. When weighing the possible theories supported by the evidence, the court, and this is the standard, must reject those evidentiary interpretations and elations that are unreasonable, insupportable, and overly speculative. Case law. The government has failed to cite any evidence that supports the conclusion that there is a reliable, reasonable, and non-speculative evidence upon which a reasonable jury could find that Mr. Finch conspired with Mr. Barnes to violate Code 666, the wink and a nod code, and that Mr. Finch knew the unlawful purpose of the plan and willfully joined in it. Likewise, the government has failed to cite any evidence that supports the conclusion that there is reliable, reasonable, and non-speculative evidence upon which a reasonable jury could find corrupt intent of Finch in December 2017 when he provided the $5,000 check, count 2, to Barnes to convict Finch. As a result, the court should grant defendant Finch's renewed motion of acquittal. There's 3 arguments that they're presenting. Here's the second one. The government recklessly misstates the evidence and Michael White's testimony. Defendant Finch argued in his renewed motion for a judgment of acquittal that the government's case hinged entirely on the discredited and inconsistent testimony of Michael White, the former city manager, and his recollection of a single uncorroborated statement purportedly made by Finch. As this court will recall, Michael White testified that there was an occasion, he doesn't know when, but it had to be after he took office as city manager in July of 2017. There was an occasion, said Michael White, where while he was city manager after July 2017, where he was out at Sheffield Park. This is Michael White talking now. Quote, out at Sheffield Park with Mr. Finch. End quote. Michael White testified that at Sheffield Park with Mr. Finch, they, quote, got to talking. about the 17th Street ditch a little bit. End quote. Michael White testified on direct cross-examination that the context of his discussion with Finch in this meeting he claims they had concerned funding, and that the alleged conversation in Sheffield Park was about financing on the 17th Street ditch. That's his quote there. See it? Quote, financing on the 17th Street ditch, end quote. Based on Michael White's testimony, the main witness against Finch, the date he started as city manager, and the unrebutted record evidence, the actual votes for the financing, defendant Finch further argued that the evidence conclusively shows that the funding associated with the 17th Street ditch was approved by the city commission well before Michael White was even hired as the city manager in Lynn Haven. Thus, because of the irrebuttable inconsistencies with Michael White's testimony regarding the funding and approval for the 17th Street ditch, by the way, which was James Finch's own money that he loaned the city, it is apparent that the government, this is so big, it is apparent that the prosecutors elicited perjured testimony in that it was factually impossible for the conversation described by Michael White to have taken place. This is case law now. Generally, okay, let's look at this footnote first. Michael White admitted in trial that the original contracts were all done before. It's kind of a big damn deal. He was hired as city manager. And then the case law says testimony generally should not be declared incredible as a matter of law unless it asserts facts that the witness physically could not have observed or evidence that it could not have occurred under the laws of nature. Now, would you agree that always, every year, that July and August come after February? The contract was signed and approved for the city to borrow James Finch's own money more than 6 months before Michael White was ever hired as city manager. So I would say that falls under the laws of nature. Wouldn't you? And the government and the prosecutors still put him up there and make him say this. Judge Walker's reviewing this now. In response, the government argues that, but the government, though, says financing on the 17th Street ditch project did come back after Michael White was there. In September of 2018, more than a year later, after they met in Sheffield Park. Wait a minute. But this argument makes several misstatements about Michael White's testimony and the evidence. Details and facts matter. First, the government conveniently ignores and fails to address that Michael White testified that the alleged conversation with Mr. Finch was specifically about financing the ditch. Second, the government's reliance on the September 12, 2018 meeting, the vote, is misguided and misstates the evidence. The record is clear. I showed you the votes last week. The September 12, 2018 commission voted to approve an addendum to include work involving stormwater improvements, not work related to the ditch. The city wanted Finch, the Bank of Finch, to loan them more money at 2.2% when the going rate was, I think, 6.5% at that time, to fix stormwater around a neighborhood where a year later, now city manager Vicky Gaynor would buy property and build a house. Is that inside information? Surely that was a big benefit to buying the property there. But it wasn't the 17th Street Ditch project. That project was done, finished, finito in 2017. This is so bad. This is so dishonest. I can't believe that a court would allow the prosecutors to put up a witness when it is so self-evident, according to the laws of nature and the sequence of time, that it's impossible to have happened. The government also conveniently cuts off portion of the September 12, 2018 commission minutes. They cut off the part of the notes, the meeting notes, that shows the motion and unanimous vote were for, quote, a separate contract. The stormwater project that they added later to the ditch mortgage that Finch gave them. Wow. The government prosecutors would have this court and a reasonable juror simply ignore Michael White's testimony and accept the government's new argument that is unsupported by evidence. The court should reject the government's unsupported argument and grant defendant Finch's renewed motion for judgment of acquittal. Third and final argument submitted today by Finch's attorneys. The government failed to present sufficient evidence of federal program structure and operation and purpose. Now, this has to do with jurisdiction, and I think I'm going to skip it. In fact, I'm sure I'm going to skip it, but I'm going to tell you where you can read it at watchdogsociety.org. Very easy to get to. Watchdogsociety.org. Click on the Finch story. Click on the link to this document. But what this does is the only way the feds can be prosecuting Finch over this is if the federal money that the city took was used in a certain way. And the government, the prosecutors, never showed ever the evidence that it was used in the way that allows this to be a federal case. That's what that's about. You should read it. You should read it. But I just don't think it's captivating. It's compelling, but it's not captivating. And I don't feel like reading 4 more pages about that. But watchdogsociety.org is where you can do it. All right. Let me take a look at your comments. John says non-existent evidence. You know, the DOJ and the FBI lost trust. That might be part of the Andrew Gillum decision, by the way. How could 12, I could see how 12 jurors could look at the recording of Andrew Gillum lying to the FBI and saying, and a few of them saying, I'm voting no, not guilty, because I don't want to see him go to prison. Because they asked the question. The jurors asked the judge how many of those 3 misstatements to the FBI, 1 charge, 3 misstatements, would be enough to send him to prison. And the judge said only 1. And so I thought, but I had heard that they had reached a verdict on that early. So I thought, well, damn, the evidence is so compelling. That was easy. So what explains 12 jurors all agreeing that Gillum didn't do what they heard him do? I don't know. But that is what is referred to as jury nullification. When you hear people talk about that, it's when a jury just says, you know, hell, I'm just not going to vote for it. I'm just not going to convict somebody on that. And that looks to me like what happened here. Also, I think there's another element that might have come into play, and that is that the FBI and the Justice Department, you are seeing locally, nationally, what they'll do and how it's become weaponized. And maybe a few people, I'm speculating now, just a couple people talking, maybe a couple of the 12 jurors that said not guilty, maybe they hate the FBI and the Justice Department. Heck, who knows? Maybe some of their family members may have been accused of, insurrection, something like that. Who knows? But I'll tell you this, I don't talk to anybody that has faith in those 2 institutions right now. It's pretty obvious what they're doing. And it worked in the favor of Andrew Gillum. And I'll say this too. This is really important. I believe in the American jurisprudence principle that it's better that 100 guilty people go free than one innocent person go to prison. And what we may have seen today is I don't get as much heartburn when a guilty politician goes free after a jury gets a crack at it than I do seeing somebody who's innocent have their life on the line like this. So it is so important that all of us, that the deck should be stacked in favor of defendants. That's the American jurisprudence. Now, that has been perverted by how the grand jury operates, by a lot of case law, and by vindictive, petty, and sadistic prosecutors, and the weaponization of our jurisprudence against political enemies. Do I think Andrew Gillum did it? Yeah, the evidence supports that. But I would rather see him go free than to see innocent people like Mayor Margo Anderson be convicted, and James Finch. And based on all of the evidence that I share with you, that is what I found. And anybody who still says that Bernie must be on the take, he's just defending James Finch, he's just defending Margo Anderson, I ask you, who has been right? The people who tell you that? The WMEB? Sheriff Ford? The Public Trust Unit? The U.S. Attorney's Office? Those involved in this conspiracy to remove Mayor Anderson from her seat? Those who were involved in this? Those who conspired with WMBB to do this? The local establishment? To include little players, but connectors, like Arthur Cullen, Todd Neves, Tommy Ham, Sheriff Ford and his Public Trust Unit, the late Derwin White, who planted evidence against her that Sheriff Ford and them used and claim is real when they know better. It's important that a defendant, that 100 guilty people go free, then one innocent person go to prison. That is what a free country has for their jurisprudence. You say, Bernie, that sucks, and I agree. Wait a minute, you just said you like it. Listen, compared to perfect, it sucks. But you don't get that here. What you have to do in matters of public policy or government structure is you have to ask compared to what? That's all you can ask. And compared to any other system, this is the best. It reminds me of what Winston Churchill said about democracy. Have you heard this? He said that democracy is the worst form of government ever devised, except for all the others. It's a very important thing to understand when you analyze government, law, and this type of stuff. All right. Yes, thank you, sponsors. Walter, long time follower. Paid parking downtown. What? Is that? I don't know about that. We'll look into it. Vote for Doc Rowan if you don't want all that stuff he's trying to save. Doc Rowan is really trying to save residents money, trying to stop this $200 million. It'll be $300 million, I bet. Rebuild of the Civic Center. Oh my goodness. Oof. It's going to be a close race. Current mayor Greg Berdnicki and them are worried, and you can vote for Doc Rowan and fix all that stuff. All right. People are getting sick live. Yeah. Yeah, that's what Michael White said to the jury. The main witness. Oh yeah, exactly. That was a big deal. All right, listen, I'm going to wrap it up. I just want to thank you for being here, and there's going to be lots more big stuff I have coming. Judge Walker can make his decision at any point, by the way, at any point. And I'll be, boy, when that comes out. When that comes out, we're going live.
You want to look good? You want to feel good? Little John's Big and Tall is where it's at, right across the street from Sky's Pizza Pie, 5700 North Davis Highway. You can find out more online at littlejohnsbigandtall.com. He's also a member of the iTex trading community, where your iTex dollars are welcome.
Hey, those of you who are still here, it is a hot time in Florida. It's getting hotter, right? And if you want the best and the most honest people to fix your air conditioner, I mean, entirely replace it, fix it, maintain it, this is where you need to go. It's a hot time in Florida, and my friend Ryan can make sure your air conditioning is running at peak efficiency. He could even install a new one, built to a higher standard, American standard. Find out more at pcairrepair.com. And as always, thank you to the Unknown Patriot for your support of my efforts to run down the truth and to let you know about it. All right, that's going to wrap it up. Thank you for being with me, and I will see you soon.